It has been pointed out that the Applied Institute is one of the premier institutes of the technology in the country, and it has a senate around to 200 members who are experts in various fields, and this senate included various distinguished and honored academicians in their fields. The state, being the highest body in the institute, was empowered under the ordinance of IIT Kanpur to take decision regarding the academic programs of the students in the institute, and it had, while approving the finding of the ICC and the SSAC, taken a decision to terminate the academic program of the petitioner respondent. In the facts and circumstances of the case, since the finding of the inquiry committee have not been disturbed and have been affirmed by the Honorable Single Judge, interfering in the punishment imposed by such a high authority of reputed academicians should not have been made lightly, and the reasons given by the Honorable Single Judge for interfering in the decision taken by the Senate is that the Honorable Single Judge has found that the procedure for arriving at the impunged decision is not immune from challenge made on account of violation of principles of natural justice. In the judgment impunged, it has been observed that the complaint dated 27th November 2015, on the basis of which inquiry was instituted against respondent number 1, had not been placed on record, and that its contents ought to have been disclosed to the petitioner, and this complaint has not even been placed before the court. This complaint, according to Honorable Single Judge, assumed significance in as much as under section 9 of the Act of 2013 there is a limitation permitting taking of cognizance within a period of 3 months from the date of the last incident where series of incidents are alleged. It has been observed by the Honorable Single Judge that only complaint which has been brought on record is 5th of January 2016, although the last incident took place in September 2015. This complaint, according to Honorable Single Judge, was beyond the period of 3 months of the last alleged incident, and if the said complaint was to be relied upon by the committee, reasons had to be recorded in writing for extending the period of limitation, which was not given. It has been pointed out by the learned counsel for the Applied Institute that institute had remained closed for winter vacations, and the complaint dated 5th January 2015 was filed detailing the instances from January 2014 onwards till September 2015, and it was not necessary for the Applied Institute to bring the said complaint dated 27th November 2015 on record, as the complaint dated 27th November 2015 was not made part of the regular fact finding inquiry, but was only the basis for the preliminary inquiry held by the ICC to ascertain whether prima facie any case was made out for conducting regular detailed inquiry. After having through the Act of 2013 and the rule framed thereunder and the handbook issued by the Ministry of Women and Child Development, this court is of the view that it is not necessary that a copy of the complaint detailing instances of harassment be brought on record. It was sufficient that respondent number 1 was given a copy of the detailed complaint made on on 5th January 2016, and this indeed was given to respondent as is evident from the reply that has been submitted by the respondent number 1 to the same, which has been filed by the respondent petitioner himself as Annexure 3 at page 45 to 59 of the writ petition.